The long-awaited Personal Data Protection Bill is finally out. The IT Ministry has requested public feedback on the draft bill by December 17th, and it can be submitted through MyGov website. This is Bhashwati Guha Majumdar, and today I will talk about the key highlights of this newly released data protection bill, which is expected to be introduced in the next parliamentary session, and how does this impact your life. So, first of all, we need to talk about what Centre has stated regarding this bill. So, according to the government, the bill will establish a comprehensive legal framework governing digital personal data protection in India. The bill also provides for the processing of digital personal data in a manner that recognizes the right of individuals to protect their personal data, societal rights, and the need to process personal data for lawful purposes. So, as per the bill, the government will have the authority to specify which countries the companies may transfer personal data to. Companies will be able to send user data to servers in the other countries outside India. So, this concept of cross-border storage and transfer of data to certain notified countries and territories is considered to be one of the biggest changes the bill has proposed. However, exemptions to cross-border data transfer are also included in the bill, including arbitration, government interests, research purposes, and others. Secondly, the bill says that the government will create a data protection board to ensure that the processed law is followed. So, this board will be able to hear individual pleas, conduct regulatory checks in companies collecting data, conduct court-like proceedings, and set up inquiries. Additionally, the bill says that the board can impose the financial penalty of up to 500 crores in the case of non-compliance, and failure to implement reasonable data security safeguards could also result in fines of up to 250 crore. Another key highlight of this bill is that under this legislation, you can withdraw consent to share data anytime you want. The bill has proposed that every data fiduciary must appoint data protection officers who will be in charge of all data consent communications. So, now to simplify this, the data fiduciary is an entity or individual who decides the means and purposes of processing personal data. It includes social media and banks also, the data fiduciaries. So, all the data fiduciaries all over India will be required to appoint data protection officers to represent the organization. So the bill states that these officers will also be responsible for ensuring that if an individual withdraws consent, the data fiduciary is obligated to immediately cease processing their personal data. The draft of the bill also includes some obligations for fiduciaries who process children's personal data. It says that no organization will be permitted to process personal data on children that is likely to cause harm, and advertising cannot target children. Additionally, before any personal data of children is processed, it is said that parental consent will be required. However, this entire bill is based on 7 key principles around the data economy that covers major areas like data storage limitations, data safety, data accuracy, and also the purpose of data collection. The IT Ministry has stated that all these principles have served as the foundation of personal data protection legislation in a number of jurisdictions. It also said that the actual implementation of such laws has allowed the emergence of a more comprehensive understanding and personal data protection that balances individual rights, public interest, and and ease of doing businesses, particularly for startups. For more such updates and explainers, keep watching First Post and